Good afternoon. This is Dana Goldberg. I'm the legal director at SeniorLAW Center. And I'm here today to talk to you about how to best protect yourself from being exploited and what legal documents might help protect you. Before we get started, let me just talk a little bit about SeniorLAW Center. We are a nonprofit legal services agency. We've been in existence for over 43 years. And we operate the Senior Law Helpline here in Pennsylvania, where people over the age of 60 and who are Pennsylvania residents can call us to get assistance. In addition, we do brief service and extended representation in Philadelphia, Bucks, Montgomery, Delaware, and Chester counties. We serve about 10,000 people every year through both our direct services and also through our educational programs like today, where we're reaching out to you to give you information on how to best protect yourselves. In terms of the actual brief service and direct representation work that we do, we cover a whole bunch of different areas. We assist older adults in housing issues, both if you're a tenant or a homeowner. We represent grandparents raising grandchildren or great-grandparents raising grandchildren. We handle consumer issues that either deal with property, home repair contractor fraud. We provide defense against guardianship cases. We give advice regarding pension rights. And then finally, we have a very extensive practice in dealing with elder abuse and financial exploitation, as well as preparing what we call advanced life planning documents, which are simple wills, financial powers of attorney, healthcare powers of attorney, and living wills. So for today, where we're talking about preparing for financial decisions, we often get to the issue of, why don't I want to think about this topic? I don't want to talk about if I were to get ill and I couldn't pay my bills. I don't want to talk about end of life decisions. I don't want to even think about who's going to help me. And I certainly don't want to think about preparing a will. And I understand that these are difficult topics and people don't want to think about this. Not thinking about it, though, can put you in jeopardy. So I urge you to pay attention to what I'm talking about, have a conversation with your support system, and then, if possible, reach out to an attorney or to our office or one of the other legal services offices and go ahead and prepare. It will protect you and it will give you options, and that's a good thing. So whom should you talk to before deciding about preparing documents or what you should do? So for those of you who have active family members and people in your family that you trust, sit down, have that conversation. Have that conversation about, what would happen if you became ill, or you were no longer able to communicate, or you're no longer able to make decisions. Whom would you want to pay your bills? Whom would you want to make decisions about keeping up the property and paying your property taxes or paying your rent? And making those ultimate financial decisions. For those of you who don't have family, do you have family by choice? Do you have friends that are there that you could rely on? What is your active circle? And then have a conversation. And you should have a conversation with the people that you think you might want to empower or have that power should something happen to you, and find out if they would be willing to take on that responsibility. So what if you don't do anything, and what if you get sick? That's not a good situation. If you were to fall ill and you could no longer communicate, or you no longer had the ability to make decisions, you've left no options in terms of somebody accessing your bank account, paying your bills, moving money if you needed to move money, providing financial information if you needed to get long-term care services brought in the home, or if you needed to go to a long-term care rehab facility. And ultimately what would happen is somebody, which could be the hospital, would file for a guardian to be appointed. You've had no input whatsoever in terms of who that person would be. Could be a stranger that's on the list of people who provide these services. And they are people that didn't know you before you were ill or before you could make decisions. And that's not a situation that most of my clients or most people that I know would prefer. They prefer to name the people that can make those decisions for them, that know what their values are and how they live their life and what they would want for themselves. In order to do that, though, you have to prepare for that. So we're going to talk about is a document that's called a power of attorney. And there's two types of powers of attorney. There's a healthcare power of attorney, which names somebody that if you can't communicate or you can't make decisions, would make healthcare decisions for you. We're not going to talk about that type of power of attorney today. What we're going to talk about is the financial power of attorney today. And this is a document that gives another person the power to handle your financial matters. However, you're not just blanket giving away your powers. The law states that as long as you are capable of making decisions and you're able to communicate those decisions, you should have the power to make those decisions. The power of attorney is supposed to be in place so that the person you name can act if you can no longer act. So that's the important. It's in addition to you. You're supposed to be able to have a say and continue to make decisions when you're legally capable. So let's talk a little bit about agents under power of attorney. So under the power of attorney, it's a document you write, and you're called the principal. You're the person writing the document, and then you're naming somebody that will have that power, and that person is called the agent. And you can actually spell out what the powers that they have for making financial decisions. You can say they have the power to pay bills, they have the power to sign checks, they can buy or sell property, and those powers can be broad or limited. You should name someone you trust, and you can also name alternates. That way, if the person that you named is not able or is unwilling to make those decisions, you've already thought about that and you've named somebody who would do that instead. And the important thing to know is that the agent is what's called a fiduciary. So legally, they're under an obligation to use your money for your benefit. They cannot commingle funds. They have to keep detailed records. If somebody asks for an accounting of everything, they have to provide that, and the court can hold them legally responsible if they handle your funds inappropriately. Do agents abuse their powers? Yes, sometimes they do, and sometimes they use the principal's money for their own benefit. So there are ways you can protect yourself after you write the document. So as long as you're capable of watching over the agent and watching over your accounts, you should continue to do that. If the agent is helping you to do certain things, you can demand that the agent keep you informed, that the agent provide you receipts, that the agent account for everything that's spent. And there are some times where you can grant limited authority to another third party to sort of act as they can't do anything on your accounts, but they can watch over that. And I believe some of my colleagues have talked about that, especially from the brokerage firms. So they're what's called a trusted individual. So you may want to talk to your financial institution about whether you could set that up so there's somebody else monitoring what's going on and what the agent is doing. What about if I write the document and I change my mind, or I find out the agent is doing something wrong? You always, as long as you have legal capacity, you always have the right to revoke that document. It does need to be revoked in writing. And then we always, when we revoke something, we always recommend that the revocation be mailed to the agent so that they have notice they no longer have that power, and that that revocation is provided to the financial institutions. Where would you keep this document? Please never keep the document in a safe deposit box because you actually have to have the document. The agent would need that document to provide them access to a safe deposit box. If it's in there, obviously they can't get it. So it should be in a safe place, preferably a fireproof box in your home, and you'll need to let the agent know where that's located so that if in fact they need to use the document, they have access to it. What if you go to the bank and the bank says that you have to use the bank's form for a power of attorney? So this is absolutely not the rule. I highly recommend that if you're going to write a power of attorney, you speak with an attorney, you have the attorney prepare that document. It's a powerful document, and so you really want to have the advice of the attorney and make sure you understand what you're including in that. And then the banks must accept a valid power of attorney prepared, and it does not have to be on a bank's form. Some people say, well, why do I need to have a financial power of attorney if I can just put somebody else on my account? So there are people who will choose to do that, but I want you to be aware that with joint accounts, there are some things that can happen. Joint accounts belong to both account holders. So the other account holder can withdraw or move money without your knowledge, without your permission. This is legally allowed. There's no way I could pull back funds from that. You're granting that authority over whatever money's in the account belongs to both joint account holders. The other thing is that the account potentially could become liable if the other account holder has debt and they are subject to debt collection, and then you have to be concerned about whether your funds are going to be pulled for some sort of debt for the other person. So that, again, I would caution you and think very carefully before adding somebody to your account. Finally, I just want to tell you that, I gave just a very general overview. I highly recommend that you speak with an attorney to discuss your particular situation and writing documents to prepare in the event that you do get ill or you can't communicate. And I've put up here how to contact SeniorLAW Center. And if you're interested in our services or to get referred to where you can get services. Thank you very much. And the more you prepare, the more you protect. Take care. Bye-bye.